Well, this is not streaming the way I want it to. Well, it's got all this craziness behind it. All right, I guess I'm gonna just do it this way. I'll redo it later. All right, I guess I'm gonna just do it this way. I'll redo it later. All right, I guess I'm gonna just do it this way. All right, what's up, everybody? Supreme Decisions here, and today I want to talk about conduct unbecoming and what are the grounds for conduct unbecoming for a prosecuting attorney. Because a lot of times we're running into these things, and one of the biggest issues that we're having is we don't know or understand when a prosecutor is overstepping. And I'm going to do that because, again, I talked about the cub, the conduct unbecoming, and that's generally the terminology that they use for a police officer. But prosecutors also have this because I talk about, again, how our system is not designed for actual law. And I give you example after example, and as much as people don't like it or people don't like him, the Tommy Sotomayor question podcast that I did a few years back, he asked the greatest question of all. Because even in the context of doing this, and in the context of doing this, you can actually see what goes on. So I'm gonna give you a few nuggets on basically how this is done and how you can spot it and some forms of combating it. Because give you the actual legal definition. Conduct unbecoming for a prosecuting attorney refers to behavior that falls below the professional and ethical standards expected of someone in that role. Because again, when we talk about the district attorney, they are the ones that are responsible for the prosecutors taking a case, which they're cherry picking. Right? Grounds for such a charge can lead to disciplinary action, disbarment, or removal from office. Because again, there are actual liabilities for this. They become liable for their actions. Why? Because they are employees not only of the government, but of you. They have a duty, which is fiduciary, because of their oath. The, ex- the exact definitions and procedures vary by jurisdiction, but common grounds include ethical violations. And I actually did this video maybe a year ago. Violating the American Bar Association module rules of professional conduct or state specific rules include Rule 3.8, special responsibilities of a prosecutor. And remember, I actually spoke about the fact that they have to disclose if a defense attorney is not defending you, if they're not requesting proper information for you on your behalf to maintain your innocence. And even the defense attorneys I've had on my podcast, both of them have been practicing more than 5 years. Neither of them had done a detailed discovery until I sent them one. When I sent it to them, they started utilizing it. They started winning most of their cases. And just from the discovery, just let that sink in. Just from the discovery, they started winning more cases. But they then became ostracized by their counterparts for the most part. And in the context of doing that, their business model changed. But because now they're not doing the thing of the system, they are being pushed away by the system. And even the context of failing to disclose exculpatory evidence, which is the most common, why? Because it's not asked for by the defense attorney, is a Brady violation. Prosecuting someone without probable cause. This is, again, Rule 3.8, responsibilities of a prosecutor, because they cannot prosecute anyone without probable cause. And if they do so, again, they have options for disciplinary action, disbarment, or removal from office, because, again, the district attorney allows them to do so. And failing to correct false testimony. I'm going to say that one more time because that's the one that actually hits right behind Brady. The failing to correct false testimony. And then we have Rule 8.4. Haven't done any videos about this, but this one is going to count. We're going to talk about misconduct. Engaging in dishonesty, fraud, deceit, or misrepresentation. That can be as small as having a defense attorney sign a plea agreement while their client is absent from their presence, because the client has a right to be there during this proceeding. Conduct prejudicial to the administration of justice. I'm going to go deeper into that later on today because, again, these are things that most people are not used to hearing or even understanding. And abuse of authority or malicious prosecution. Malicious prosecution is probably the most common thing that any of us hear. And these are the things that also allow us to go deeper into the lawsuit, because generally your lawsuit that you file will be based on malicious prosecution, which is also abuse of authority. Now, when we're talking about the abuse of authority, we're talking about the abuse of perceived power. Now, coercing or threatening witnesses. Yeah, I want that to sink in a little bit. I pause for dramatic effect because I want you to understand even a prosecutor will coerce or threaten witnesses. How do they do that? They coerce a witness by telling them, if you don't do X, Y, Z, we're going to put you in jail. Now, give you something from my case. There was a young lady, and you know what? I'm gonna keep it PG because it was a funny instance. It was the first time I had actually been in that situation. So I'm going into court. It was a young lady. I told her, hey, there's a material witness warrant that has been issued for you. So what she did, she put herself together. She turned herself in because, again, it's just material witness. Nobody cares, not a big deal. Well, she ended up sitting in jail for 60 days. So when we went to the first preliminary hearing, I was actually happy to see her. My brother grabs me and goes, she's not on our team. And I said, what do you mean? You know, he goes, she just got out. Now, unbeknownst to me, I didn't know she was in jail because, again, it's a material witness warrant. It's not something that I know of being arrestable for. Well, he was right. She had just got her clothes out of the bag. And what that meant was they threatened her to testify against me, and she accepted a deal, absent committing a crime, which was the most hilarious thing I'd ever seen. She took a deal for RICO that offered her 25 years on probation. And they told her in front of me, which was the most hilarious thing ever, because I was like, how is she taking a deal on RICO and she was never charged with anything that had to do with RICO? She was a witness. She took a deal for 25 years on probation. And they told her, if you violate any stipulation of this probation, we're going to make you serve every day of this. And I was like, that is crazy. But that is coercing and threatening a witness. And yes, It is something that is more common than most people think, because you'll see people testifying that are not in jail or even not supposed to be in jail. And you'll wonder what happened. A lot of times it's just because they don't understand the law itself and the pressure that's being applied to them. And yes, this was in 2010. Just think about that. Because just give you another example. Young man, Gilbert Arenas. Gilbert Arenas is being charged with a conspiracy. I looked at some of the evidence that they put out, which was kind of funny to me for the most part. And the context of it was, how are they charging him with anything when all they have is a picture he sent to the person he was renting his house to? Oh, they're trying to use him to get to these other people. He's a pawn. So they thought threatening him would then get him to testify. Well, Gilbert's got a little bit of change, so his lawyer is telling him they don't have anything, which is why he's now playing on the internet, why he's joking about the situation, because he's also informed. And yes, and it's one of those deals that most people don't catch on to, because you've actually seen a lot of people make videos. Oh, what is he going to do? Is he going to turn himself in? Is he going to do the time, or is he going to snitch? There's nothing to snitch about. They don't have any real evidence against him that deals with that conspiracy, other than the fact that he rented the house to someone and they carried on something. And he had looks like a jovial conversation. Just, hey, why don't you do this since you play poker? This is your poker night. Make it Gil's place because it's Gilbert Arenas' house. That was part of the selling pitch. Yeah, we're using Gilbert Arenas' house. So that was one of the things, which is why they're trying to tie him into it. But again, they're trying to coerce and threaten him. But he's not allowing it because he's legally informed. Now, overcharging or charge stacking. Now, this is done more often than not just to actually get the win. They need a W in the column. So they're forcing the plea. And then here's my next favorite one. Withholding evidence during discovery. Now, this is why you have the detailed discovery. Whenever you're putting this together, that is when you go out and make sure they're doing what they're supposed to do in the fashion in which they're supposed to do it. Because everything that I show you in your detailed discovery that's need to be requested, it is codified. They have to turn it over, whether you request it or not. But if you do it in writing, you can now hold them liable for this. And now, one of my funniest things, and because it goes two ways. They'll give you bits and pieces, and they'll say, oh, well, that's all I need to turn over. And most people be like, oh, okay, I got something. And they're happy with it. No, I want everything that's on that list, because on that list, I might have some more stuff that I want to add on to it. But here's my favorite one, because this is one of the things that was done to me. It's when they don't withhold discovery, they just give you so much discovery that you don't know what you're looking at. And that's why you use the detailed discovery, so you can actually pick out what it is that you need. And now later you can go through those extra pieces of paper, because in that extra piece of paper, the devil's in the details. When they give you more than what you asked for, you use that against them as well. So always understand, their abuse of power can be done in multiple forms, and even selective or retaliatory prosecution. These are things that are done when you fire back at them. Because most common, I fired a shot at they were using outside counsel. So outside counsel then filed for sanctions against the pro se defendant or litigant. Okay, cool. Because now we're going to throw that back at you, because we're going to use that against you in the federal realm. In the federal realm, we're now going to put you in the chokehold because of you're trying to be retaliatory. And even at times, engaging in racial, gender, or religious discrimination in charging decisions. Now, this was something that showed up in my trial again back in 2012. Not in paperwork, not during the actual cross-examination portion of the trial, but in the closing of it. And it was done by, a Baptist preacher, which was, kind of ironic because it was also unnecessary. But at the same time, it turned off the jury, which helped me be acquitted. Thank you for being dumb. But these are things that can be done. It can be found in an email. It can be found in a tweet. Hell, these prosecutors love the internet and being on TV and all these things now. It can be found in an interview. These things, while they're little small innuendos, these are things that can be held against them as abuses of power. Now, we'll go into basically power tends to corrupt, and absolute power absolutely corrupts. And there have been instances where I've actually gone after district attorneys. One of the ones I did go after, I want to say 2020, was the one in, what's the county in Houston? Had one in Fort Bend County that was that actually he just resigned, and the second one was Harris County. I want to say it was a young lady in Harris County. She also didn't resign. She just did not run, because when you're then poking at them and you're going after certain people, they then tend to kind of back away from you, or whenever they're going too far and they've actually put out evidence against themselves, they'll kind of make themselves smaller, or they'll kind of shrink away. Now, the purpose of when we're doing this segment, right? We also talk about improper public statements. Those are the things that are done during the interview, because what the prosecutor is trying to do is taint the jury pools or damage reputations before the trial, because that is one of the reasons why when someone first arrested, they put you in the paper, or they'll put you, the jail report down in Georgia. I can't think of what it is here in Texas, but they put you in some type of report. They put you with your mugshot, and then they say, oh, this is what they're charged with, because they're attempting to damage your reputation prior to trial. And the prosecutor then, because here's the thing, I always tell everybody, go for a jury trial, because that way you have literally regular people. And then you can actually go to the fact of human nature and go into these conversations. But what happens is they're trying to paint you as such a bad person prior to you, like any evidence being shown, if any, that you choose to take a plea, or you choose to not fight at all, because you're worried about your past, because we've been trained to actually worry more about what's behind us than what's in front of us. And that's one of the reasons why I always tell people, I've been a monster a long time. I don't care about all that, because that's what's made me today. And even in the context of that, I've done things and I can't undo them. If you don't like them, it's cool. Let's keep moving, because what I am now is because of those things that I did. And it is what it is for the most part. Now, the next part is witness tampering or intimidation. Now, we talked about the threats. Let's talk about the coaching. Whenever they do have this threat that's already in place, and they go in, and what happened to Attorney John Melvin? That's a great question. Last I heard, because he was going, all he had to do was beat me to become a judge. Well, when he lost, one of the things I made a promise to him was, I'm going to take everything you believe you love. What I understood was, because he actually lost his job, because I believe it was James Evans, and I hate to say that because it sounds like good times. He was the DA at the time. He was fired, And then he actually opened a criminal practice. He just so coincidentally did not use my case as one of his bolstering points. John Melvin was also fired, and so was Jody Fleischer, and not necessarily fired from Fox, but she was actually removed from the DeKalb County area for that particular building and or prosecutorial team. I forgot who they had, but he then lost half the members of his church. I believe, I don't know if it went through, but I do know his wife had filed for divorce, and a few other minor things happened. And I was actually good. I left it at that. Because again, most people have no idea what love is. And when you take half of what they believe they love, it becomes more satisfying to me, because to beat a monster, you have to become one, but you don't have to allow that monster to become who you are. Now, of course, I'm the Hulk because I'm always angry. So, tomato, tomato. But even in doing that, they're coaching someone to say something. And even in my case, again, it was brought up that shoot me an email, greatestnow@yahoo.com. Greatestnow@yahoo.com. But even in my case, it was brought up on the context of, how do you say that? They was coaching a witness on what to say, and my brother's attorneys told me to object because I was sitting first chair. And I told her, no, let him keep talking. Because even in the context of that, he has to prove everything he's saying. And what happened was, he talked himself into a lie. And one of those lies, because he wasn't properly coached. And the reason he wasn't properly coached is because they did not prepare him for me, because there was no footage of me cross-examining anyone. So therefore, they were ill prepared, because they were preparing based off of hypotheticals, if that means anything. Right? So even in the context of that, the preparation can be done, but you can still go after the human nature of any action. All right, and failure to correct false testimony. If the prosecution fails to correct something that they know a witness is lying about or doing, this is misconduct. This is oftentimes either a statement that was prior made, how do you say that? A police report, because that's what they're basing most of their charges from. This police report where a witness made a statement in that report, where they'll actually get them to clean up or make it more towards their story when they're doing that. That is a lie, and that is misconduct. But proving that is probably the most difficult, other than the fact that they, what they call it, is because it's not suborning perjury. It's one of that, it's in that gray area, which makes it difficult, because it's like, well, oh no, I just said this. And generally, if you give someone a story, by the time they tell the story 2 hours later, the story is going to change. And generally, most of these cases would take 6 months, 3 years, if not pushed properly. And there's going to be discrepancies in that conversation. So they use that as a barrier or a hiding point. But again, these are things that you're going to learn if you take the master class on how to handle. Now, consequences for prosecutors. How misconduct harms real people with wrong convictions and lost years. And even what the consequences should be versus what often happens. Now, again, this is one of the things that I spoke about before, because you have people that are convicted based off of misinformation, or a judge going rogue, or even a prosecutor not doing what they're supposed to do, or even a defense attorney not defending. In the context of this, you have to also know what it is each one of those people are doing, because again, these are chess pieces. You're using your defense attorney as an assistant because you are the employer. You are using the prosecutor because the prosecutor is placed into a box, which they can't go outside of. And if they go outside that box, it goes for your advantage. That judge is in a box. They have rules in place. If they go outside that box, you can actually go after them and do things like that because they become liable for their actions. The first part of that is go to your disciplinary board or your review board. In some cases, you can go after disbarment. A lot of times it doesn't happen. It has to be absolutely egregious because most people have no idea what the actual system is. So the system itself then becomes whatever you allow it to be. And sometimes, and I hear this more often than not, well, I want to go after them criminally. Well, you're asking a piranha to eat a piranha, and that generally doesn't happen. Now, has it happened? Absolutely. It's happened 1,000 times. It's just not something that you're going to see stick because they don't go after each other. Now, civil suits generally bring up qualified immunity because each one has a barrier. Once you understand what that barrier is and how to get around it, it's understanding how to challenge it and how to effectively use it for your betterment to get the things that you're looking at. And the legal remedies, we go into how to file a complaint with the state bar because again, it's verbiage, it's action, it's proof, because it's not what you know, it's what you can prove, and it's also where you're doing it and the time of you doing it. Filing a motion for prosecutorial misconduct. Now, that's just some, I'm gonna tell you now, I've only done it a couple of times. Neither time has worked. However, we used it as grounds because again, it's a tool. Understand the motions itself are tools. You use that tool for a later movement. And again, both times they were dismissed, but we used them later in federal court, which allowed them to come to a settlement, and neither one of them paid me, but don't worry about that. And how to request a hearing based on a Brady violation, a NAPU violation, or a Giglio violation. Because again, all of these are set up in discovery. So you have to keep in mind what those things are and why those things are. Because again, when we're talking about even FOIA, Freedom of Information Act requests, or subpoenas to expose the misconduct, because again, the subpoenas will be the things that are set up for your emails and the business related transactions during your case. Because it'll be Giglio, witness credibility in deals. Napara v. Illinois will be dealing with false testimony. And Young v. United States, abuse of prosecutorial discretion. Because again, those are things that are left for the district attorney because the prosecutor can't do anything the district attorney does not allow them to do. Now, let's basically recap. And because again, I'm going to be back on, it's actually going to be the right way instead of like this later. Know your rights. Demand ethical behavior from all sides, especially those that are in this court setting with you. Use the law to hold the prosecutors accountable. And understand the state bar complaint forms, the National Registry of Exoneration. And I haven't found them to be very helpful yet, but the Innocence Project support. But the whole point of this is don't be silent. If a prosecutor crosses the line in your case, make your next move count. Because as they always say, make your next move your best move. And this is your next move. When you turn legal knowledge into legal power. This is Supreme, And I'll see you guys in a couple hours.